Hi, everybody, and welcome to today's webinar. Today's webinar is about buying a home in British Columbia. I'm your host, Paula Price, and joining me are lawyer Michael LeBeau and notary public Farnaz Kovacevic. But before we do that, we just wanted to extend our thanks and acknowledgement. First, we'd like to acknowledge that the land on which the People's Team is gathered is the unceded territory of the Coast Salish peoples, and that is made up of the Musqueam, Squamish, and Tsleil-Waututh First Nations. We would also like to extend our thank you and acknowledgement to the financial support of our funders who make this webinar possible. And those include the Law Foundation of BC, the Notary Foundation, and the Department of Justice Canada. And last but not least, I have the pleasure of introducing our speakers. We have a notary public, Farnaz Kovacevic, and I've known Farnaz for a number of years. We used to work together, and Farnaz is one of those incredible combinations of being extremely detail-oriented and also a very lovely person to work with. And we are delighted to have Farnaz here. She has a notary practice in Coquitlam. She's been practicing there for a number of years, and we're so delighted to have her here today. So welcome, Farnaz. It's so nice to see you.
Thank you. Thanks for having me, Paula.
Such a pleasure. Thank you. We also have Michael LeBeau joining us today. Michael is a lawyer. He also has his practice in Coquitlam. And I had the chance of speaking with Michael in preparation for today's webinar. And what really struck me about Michael is he is very engaged and attentive to the needs of his clients. And so the purchase of a new home, for example, is it's probably one of the biggest purchases that most of us will make in our lifetimes. And he's very sensitive to making that process comfortable and accessible to his clients. So we're really delighted to have you here today, Michael. Welcome.
Thanks very much, Paula. Happy to be here.
Excellent. So with that, we're going to jump into our questions, starting with this question, which is for Michael. Michael, we've got an image here of a newlywed couple. They're all excited. They're ready to buy their first home. What are 3 things that a home buyer should look out for when it comes to their legal rights or potential pitfalls?
Well, I think they should probably look out for a property with a yard, because when you have to take a dog up and down an elevator every day, it's a bit of a hassle, but that might not be our main focus. So realistically, one of the main things that I think people need to look out for is that their contracts, and I say contracts because you have both your contract for the property and your contract with the bank for your lending, actually reflect what people are intending. We see a lot of instances where people are buying a property and their contract will say something like, the seller has to fix the hinge on the kitchen cabinets and the sliding glass door. But it doesn't say what happens if that doesn't happen. It doesn't have any holdback or deficiency requirements or anything like that. It just says that the seller has to do that. And then a buyer will come to me and they say, well, what can we do about it? They haven't done it. We've moved in and now we have to put out our own money to do it. And the answer is nothing really. I mean, you can sue to try to recover your costs, but how much do you want to pursue a lawsuit over a $150 repair? So it's very important that your contract actually reflects that from the outset. So if you are intending to have particular things happen, it has to be in writing, it has to be part of the contract. And it's never a good thing to operate on the everyone knew what we meant principle. It really should be very clear and outlined in the contract. When it comes to your mortgage agreement, you want to make sure that your payments are structured the way you want, the amount is what you're expecting, that you are you're prepared for all of the clauses that the bank has in terms of terms and conditions that you have to meet, if you have debt payouts that you have to complete or that kind of thing. So which brings me to my second point, is that it's really your responsibility to know what you need, while your broker and your real estate agent and your mortgage advisor are both there to assist you. They are not, it's not their responsibility to get your stuff done. So if you're presented with a mortgage commitment, for example, that says that you have to close your credit card and your line of credit, those are going to have to happen. We have to make that happen as part of completing the transaction. So it's really important that you're aware of what's needed. Don't just sign stuff blindly and say, oh, my broker never told me. Well, you initialed the page that was on, so one would think that you actually are aware of what's in it. So it's a really, really important thing that you're aware of what conditions you have to meet and what's involved in it. And the last thing is, this comes up too often. It's a really important thing that people are aware of their funds availability and all the conditions that they have to meet. So in theory, your mortgage advisor will help you get to the stage where you know how much money you're going to need to complete the transaction, which will include things like property transfer tax and other costs, legal fees and adjustments for property taxes and that sort of thing. And you need to make sure that you have those funds and that they're available. We had a client in recently who said something like, oh, what is this property transfer tax thing? That should never be a question by the time you get to me. So that's always a bit of a concern. But on top of that is that your funds are actually available. They're not tied up in an RSP or a TFSA or overseas waiting to be wired from your parents from Australia or whatever the case. They actually have to be in your account and available and ready to provide to us so that we can complete your purchase.
Fabulous. Thank you so much, Michael. Michael, I just wanted to note, I'm sorry, I forgot to introduce Parveen. Parveen Gill is with Michael in his office. She's recently joined the firm. She's learning about real estate transactions. Thank you for being here as well, Parveen. And Michael, I just wanted to touch on that then. So really what home buyers should be looking at is understanding the contracts, making sure they have the right contracts in place, knowing that they are to do their part. So making sure that they know what's contained in those contracts so that they are able to fulfill any obligations. And then that last part about really being able to meet all the conditions. So if it's the question of financing, making sure that the funds are available and anything else that needs to happen at the time of closing.
Correct. Yeah, those are all, they're just some of the key elements that people need to look out for.
Exactly. Thank you very much. Farnaz, this next question is for you. And the question here is what will a notary or a lawyer do for me? What role do they play in the transaction of buying a home?
Surprisingly, I get this question a lot. A lot of times people think, oh, what do I need a notary or lawyer for? Well, we are actually the last stop when it comes to purchasing your new home. We will prepare the legal documents to ensure the property is transferred from the seller to the buyer. We also review the contract. We will review the title search for you and let you know if there's anything that you should be concerned about. We review tax certificate and strata information to make sure that it's adjusted accordingly between the seller and the buyer. If you are getting a mortgage, we prepare the mortgage documents to ensure the bank has security for the funds that they're lending you. We also act as, I guess we handle the transition of funds. So the bank will be depositing the funds to our trust account. You will be bringing us the down payment, and we will facilitate between our office and the seller's notary or lawyer's office. We ensure the seller has clear title for you. So if the seller has a mortgage on their property, we will do all the follow-ups to make sure that their mortgage has now been removed and your new mortgage is on the title. And also ensure that the seller's paid everything up to date. If there's anything outstanding against the property, we definitely follow up on that and make sure that we receive proof of payment of taxes, utilities, strata, and so on.
Thank you so much, Farnaz. I love how you described that as the final stop, right? The last stop. And it sounds like all these things are obviously very critical to the transaction, the transfer of funds, and making sure that what you receive at the end of all that is the clear title, that all the encumbrances or other things have been removed from the title, so you get what you're paying for effectively. So thank you for adding some clarity to the role that you or Michael, for example, would play in that transaction. This next question is one that that Michael and I talked about, which is what is the difference between a notary and a lawyer? And I understand that's a question, Michael, that comes up quite a bit in your practice.
It is, and I think it's actually one of the questions in the Q&A as well right now. Ideally, nothing. If everything's going well, nothing. Farnaz and I should hopefully be conducting the exact same duties and getting the transaction complete. Where it really comes up is if something goes awry. That's when the difference matters, because the limitations with notaries is that they're not able to give advice on contentious legal issues. And so if it starts to go down the realm of problems, I guess is the simplest way to put it, where there could be, maybe giving advice on whether or not you need to be looking at suing, for example, like when we were talking about the missing hinges or whatever. Those are the kinds of things where it does require a lawyer to give advice, and there's a certain stage, and Farnaz might be able to speak better to when that happens, because I don't hit that stage, when a notary is sort of obligated to pass off the file and say, I can't actually advise on that. You'll have to speak to a lawyer about it. So that's the primary limitation in why there is a difference and what the main thing is. But ideally, and in 99+% of transactions, there isn't really a functional difference. We are conducting the same thing. The notaries are highly trained. The lawyers are highly trained. We're all trained to conduct and complete the transactions the same way.
Fabulous. Thank you so much, Michael. And Farnaz, do you have any examples of what might come up that would where you would say, okay, I need to refer this over to a lawyer? Like, do you have any other examples?
I have, I guess, I've had a couple of times where my client as a buyer or as a seller decides they want to back out of the deal. And at that stage, I have referred them to a lawyer to make sure they get proper legal advice. Like Michael said, I don't do litigation, I don't do court work, so I would not be advising the client what that next step would be. And a lawyer would be able to say, okay, if you walk away, you might lose your deposit or they might sue you, So in those cases, I have referred them to a lawyer.
Thank you so much for that, Farnaz. That adds further clarity to what Michael was saying about instances that you might look out for, where a notary or a lawyer would be more appropriate. So let's move on to our next question. Now, this one is for you, Michael. We'll also be asking Farnaz for her input. How much will this cost? How much does it cost to see a lawyer, to have the purchase basically effected through a lawyer or a notary?
Sure. Short answer, it can vary quite a bit. A lot of it's circumstantially dependent. I like to operate off a base rate principle. I try to be very transparent with this because I never want to have a client sit here and show up in the meeting and say, you didn't tell me about this, or I put it right on the website. I say, here's our starting point, and it can go up from there. And here are some of the things that can affect the pricing. So if you're doing a standard purchase with let's say a big bank mortgage kind of thing, we start at $1,400, and that $1,400 is inclusive of our legal fees, taxes on our fees, and the standard land title search and registration costs. The cost for us to use the software that we use eConveyance. And I don't charge for things like photocopies or file opening fees or whatever. That's just part of me running my office. So I don't like to have extra things show up on a bill because it's, in my opinion, it's a little bit artificial. It's just part of my cost of doing business. And so I give you a base total, but then there are things that are variable from transaction to transaction that we also have to pay for on your behalf. We have to acquire documents from the strata. We have to get a title insurance policy. We have to get tax certificates from the municipalities. We have to get proof of insurance from the strata's insurance agent or your home insurance agent if it's a house. And so there are various things that cost money that we go through us that are, they can range quite a bit. If you're doing a cash purchase of a strata property, your title insurance policy with the provider we use is going to be $90. If you're buying a $1.5 million house, that same title insurance policy is going to be something more like $400 or $500, maybe even a little bit more. And a tax certificate can range from a property in a regional district for about $9 to $85 in the city of Vancouver. So there are things that can range quite a bit cost-wise. And so those are not included. But then there are also other complicating factors, like if your lender is, say, a monoline lender where their documentation is a little bit less standard or their process is less standard, we charge extra because we have more work we have to do. So usually it will be an extra $100, sometimes $200. If it's a real more, quite a bit more complex lender, it might be $300 or $400. When we get over $1 million, we charge an extra $100 because we have additional insurance that we carry to cover ourselves over that $1 million price point. So there are a variety of things that can make it more complicated, and those will always cost extra, of course. And then the sale process tends to be quite a bit less expensive because more of the process is undertaken by the buyer side. So the sale side tends to be less expensive. A sale with one mortgage to discharge, we start at $950, and then it can go up from there again, and similar depending on the circumstances. And of course, if you don't have mortgages involved, it's always less expensive because there's less for us to deal with and that sort of thing. So.
Fabulous. Thank you so much, Michael. I noticed when I was looking at your website this morning that you have all the prices laid out quite nicely. This is very clear, and much as you've described just now with the basic rates, and then those, almost an inventory of the things that might cause the fees to increase. So right. Anybody who's interested can go to your website and see that information. Farnaz, what about you? What's the sort of general cost of a conveyancing?
I think most offices were pretty competitive, so our prices are pretty much the same. I mean, Michael, that's a good idea. I should probably put mine up on my website too. We try to be as transparent as possible because same thing, I dislike if a client comes and they think, oh, well, you didn't tell me this, or that, they call the hidden fees, we don't have any hidden fees. We do charge extra depending on the transaction. Like Michael said, some transactions are going to be more complicated. If you're buying a foreclosure property or a new build, if it's sale by power of attorney or executor, we tend to charge more for transactions like that. I had to write down what I charge because I normally don't quote with taxes in, but if it is a regular purchase, under $1 million with one of your regular banks, with the taxes, with registration, the searches, everything that Michael said, you're looking at $1,445. And then all the additions, like you said, which I'll touch on a bit later, the third party closing cost is what we call them. Those are additional, of course. If it is a sale with one charge, whether it's a mortgage, line of credit, or any other charge to be removed, it is $1,055 all in. But again, it really depends on the transaction. When people call for quotes, I tend to go over a list of questions, are they residents? If it's a non-resident we're dealing with, we're going to charge more, it really varies from transaction to transaction, but that is the base prices. Yeah.
Excellent. Thank you so much, Farnaz. And so what I'm taking from that is, and I like what you said, it's competitive in the sense that the fees are probably pretty much in alignment with among professionals who are doing these conveyancing. And the best way to know how much it is going to cost is to be having that conversation up front with your lawyer, with your notary, where you're explaining what the transaction looks like so they know what items are actually going to be required to effect the conveyancing. Fabulous. Thank you very much, both of you. Farnaz, this next question is for you, and it's following up on the topic of how much this costs. So the question here is, why do I have to pay the lender's legal fees, and what other expenses might come up in the course of a conveyancing?
The lender legal fees, it's always in the paperwork that you sign with the lender. They are lending you money on the condition that you will pay any cost associated with that money that you're borrowing. If it's one of the regular banks, the banks normally will allow you to sign an authorization consenting to the notary or lawyer to act for you and the bank. So it may seem like you are paying one legal fee at that point, but the reality is we charge more when there's mortgages involved. So you are paying for the bank's legal fees as well. If it is a private lender, private lenders will have their own legal rep. You will have your own legal representation. So again, in the paperwork, it is a condition that you have to pay for their legal fees. You're borrowing the money, so all the costs will be to you. As far as what other expenses might come up, so the third-party closing costs that I touched on earlier when I was giving the quotes for the purchase and sale. So the third-party closing costs that Michael mentioned, the tax certificate, the strata forms, insurance, these are all, these charges vary from transaction to transaction depending on who the insurance company is or who the strata management company is. Has your realtor ordered a form that we require? Is the form still valid, because they do expire? So you need to keep that in mind. If it's a new build, GST, I mean, the realtor should also advise you that you have to pay 5% GST if it's a new build. And of course, property transfer tax, that's a big one. As Michael mentioned in the beginning there, a lot of clients forget about the property transfer tax, or maybe are not aware of it and don't understand it when the realtor goes over it. But that's a big one to remember. It is 1% on the first 200,000 of your purchase price, and then 2% on the balance up to the $2 million mark. And then it increases, of course. And then adjustments between you and the seller. There's property taxes, there's monthly strata fee adjustments, there might be utilities. So that's all to consider as, additional expenses that'll come up that you may not be aware of.
Excellent. Thank you, Farnaz. And these are all things that that a home buyer would want to have forecasted in their budget, so that they've allowed themselves not just the purchase price of the home, but the fees and the additional costs that will be added onto that.
And sorry, title insurance as well. That's a big one. More and more lenders require title insurance, or if you want a survey certificate, sometimes client may want to get a survey certificate in lieu of a title insurance. A survey can cost you $500 or more, depending on, if you're going to get a land surveyor or a registered BC land surveyor versus a non-registered one. So yeah, there's that too.
Thank you for that. This next question is for you, Michael. And I understand from speaking with you that there are a number of questions that come up around the actual execution of the documents. And so the question here is, what do you need to make that process effective? So do all the home buyers, for example, need to be there? Can you DocuSign? Can people come in separately? So what is required for that actual sort of conveyancing? What do people need to do?
Sure. So the main thing that people need to be aware of is that everybody that's directly involved, that's a party to the transaction, needs to be part of the signing procedure. At the end of the day, you're buying a property, and if your name is part of that, even if you're a parent that's effectively co-signing, but you're having to go on title, you have to sign the documents too. You can't sign for your spouse. You can't sign for your brother that's out of town. You can't, and no, you can't just DocuSign the documents. So realistically, you have to be prepared to either come in for a meeting, or in certain circumstances, and if your lender will allow it, there are instances currently that probably won't last for too much longer, but there are currently instances available for conducting the signing by video, very much like what we're doing right now. And those are, but that's still pen on paper, ink signatures, and pointing the camera at your page, or holding up to see this, I've signed it now, and that kind of thing. So there is quite a bit that's involved in it, but for the most part, the actual signing process and who has to be there is everybody that's involved, like I said, Doesn't always have to be together. We can have instances where we break up the meeting because either it's parties that don't get along, in some instances there's the sale of a property where parties are separating or divorcing or something like that, or just availability reasons. And the reason that we can't do DocuSign is because the land title legislation in BC requires pen on paper, and also the lenders primarily want written signatures. They don't want somebody to have just clicked, because that in theory could be done by somebody else, not the person actually doing it. If it's a click here to sign for Susie Smith, and John Smith's the one clicking, then you're going to start to have Susie contesting the validity of her obligations to the lender or that sort of thing. So that's one of the reasons that lenders don't want stuff DocuSigned as on the final part of the procedure. So
Excellent. And that makes sense. Wow. You can imagine how that could unfold. Thank you so much, Michael. The next question is for you, Farnaz. And the question here is, can you give a personal check?
No. Simple answer is no. I mean, you can give a personal check if you wanted to pay for legal fees, but as far as the down payment, no. The money that you bring in has to be guaranteed funds, because we deposit the funds to our trust account, and then in turn write checks to other parties. So the seller's notary or lawyer, or if we're acting for you in a sale, your bank, that has to be paid out. So you bringing say an $800 check will not work. And we also have trust rules for our trust accounts. So as notaries and lawyers, we have trust accounts where we're holding the money in trust for you in order to be able to facilitate the transaction. So the money that we deposit to our trust account and then write checks to other parties, now we're guaranteeing those funds. So no, it has to be a bank draft. In my case, I think the society trust rules are different than the law society trust rules. I think for lawyers, you could also bring certified checks. Am I correct, Michael?
yes.
Yes, okay. But for notaries, it has to be a bank draft.
Another thing that we do on our end too is we let clients transfer funds from their fund. Like if you have your money at Royal Bank and we have a Royal Bank trust account, they can transfer the funds right from their account into ours at the teller kind of thing, because then it's guaranteed funds and the teller's ensuring the funds are there to transfer and whatnot. So,
And
which I think you might not be allowed to do that.
No, we cannot do that. You can go to the bank and prepare a draft and have the teller call me, and then we'll provide the teller with deposit information. The teller will have to deposit, but you would still have to prepare the bank draft. We cannot have transfer between accounts.
Excellent. And that leads to our next question, which is, can you just e-transfer me the completion fund? So from what I'm gathering, Farnaz, in your case, it's a no.
No.
And Michael, in that situation where you have is it still a no? No e-transfers? Is that different?
I can receive e-transfers. I can't send them. I can't provide the money to you with a e-transfer going to the teller and just moving the money. Technically, we are able to wire money, but it's quite a bit more costly and time consuming. So people say, oh, can't you just wire? You're just going to wire me the money? And say, well, if you want to pay me the extra $150 I'm going to charge you, then sure. But otherwise, no, we'll go and deposit a check into your bank account or that sort of thing. Because e-transferring, there's very strict rules for, it's basically the paper trail from a trust accounting audit perspective. That's why the rules are as strict as they are, and why I can't just send an Interact transfer for the $2,500 that's left in trust to send it back to you afterwards.
Excellent.
And like Michael said, we can prepare, we write a check out of our trust, and then, if the client's out of town, we'll deposit it. We will deposit the check to the client's account, but no e-transfers, no.
Yep.
Okay, super. Thank you. So moving on to our next question. We've got a very happy couple of people here on the screen with their keys in hand. At what point does the purchaser get the keys to the home?
So that can be a bit of a question that people don't always like the answer to it. And again, it's about not understanding what's in their contract. But the you should get the keys at the possession time that's outlined in your contract, and you would get the keys from your realtor at that point. Usually, your realtor will meet you at the property and hand over the keys, and off you go, kind of thing. But I often have people that say, okay, well, I need the keys at 10 a.m. that morning because the moving truck's coming and we're going to be there and ready. And I say, your completion date's at 10 a.m. and you have a credit union mortgage that we can't even get the money from the bank until we register the transfer. And like, it's probably not going to be done till the afternoon at the earliest. And your possession date isn't for 3 more days. So why did you book a moving truck for 10 a.m. on your completion date, kind of thing? So that's something that does come up fairly often, but anticipate that you should get the keys on the date that's laid at the time that's listed for possession in your contract.
Excellent. Okay, so that's where you need to look. Thank you, Michael. And make sure you don't book the moving truck in advance of that date. This next question is for you, Farnaz. So we have a situation here where the sale is going to close in August. And the question is, when does a person need to see either a notary or a lawyer?
Normally, a few days prior to the completion date, everything comes together really towards the end. I guess it also depends if you're getting a mortgage. You know, some banks will require documents signed and returned maybe 3 to 5 days prior to the completion date, so they can make sure they review everything and then have funds in order for the date. But in most cases, you're looking at a couple of days before. If you're selling and you want to sign sale documents, most times we don't get the documents until a few days prior to the completion date. So sometimes clients call and they're selling and they're like, oh, but I'm leaving town. I want to sign 3 weeks earlier, a month earlier. It makes it really tough. You know, we can request documents, but we can't guarantee to have documents for you to sign any sooner than that. With purchases, there's more of a flexibility. You know, I've had clients who are buying and, they had to leave for a business trip, so they won't be there maybe 2 weeks prior to the closing date. And we have arranged to have them sign sooner. This is, of course, if we have the mortgage instructions as well. But normally, I would say a few days prior to, sometimes even the morning of closing, if we don't get the documentation we require in on time. So it has happened.
Excellent. And Fairness, when would you need to kickstart that process? Like give you the heads up that this is happening? How many weeks before the anticipated closing?
The sooner the better. Ideally, a few weeks before. Mm-hmm. Sometimes we don't get transactions, especially with the market being the way it is right now, and it's really busy. So sometimes we get transactions and 5 days before, a couple of days before. So it's really up to that individual office if they'll accept it, but I would like it at least a few weeks prior if possible. It just gives us time to see and just be organized, make sure we have, whatever we need for you to come in and sign.
Thank you very much, Farnaz. And what about you, Michael? I understand that what happens in your office?
Similar, yeah. It's right these days, we're basically at a stage where we're turning people away if they're trying to close too quickly. There just isn't room. There literally are no more hours in the day. There are no meeting slots available. Staff can't handle any more files because everybody needs to go home at some point. And so these days it's a little bit of a tougher situation than normal. But we usually say like a minimum of 2 weeks is kind of expected for things to go smoothly and not have any sort of unexpected issues. 3 weeks is closer to ideal. Longer, the better. But the problem isn't necessarily knowing that you have a deal coming up. The problem is actually having stuff come in. I remember a situation from a little while ago where a client called me in October, I think it was, and said, can you help me with my transaction in December? Yeah, sure, no problem. I think the deal was closing on December 15th or something like that. And stuff didn't start to show up until December 11th or something. And at that point, there was no room anymore. I hadn't heard anything from the client since that first initial phone call. No mortgage documentation, no real estate documentation, nothing had come in, and we didn't have room. He said, but I called you in October. I said, and nothing came in. We didn't have anything for you. You didn't exist, basically. In terms of, I can't just hold time hoping that something's going to happen and not knowing if there's anything that's going to come through. So that's a bit of an issue that can occur sometimes, and especially at busy market times when there isn't a lot of staffing availability, that becomes a problem. Don't try to rush it when there's not enough time. It's not going to work.
That's really helpful. So in that case, for example, then the person who's seeking you out then needs to make sure they're following up. Is that with their mortgage, their lender, with is that because you're waiting for paper? So who does
Correct.
a person need to follow up with to make sure that there's not some other holdup that prevents you from being able to close?
I finish every conversation with the client when they ask me if I can help them, to make sure you let your realtor and your mortgage advisor know that I'm helping, and they'll get me the documents, because we can't even open a file without your documentation. There's nothing there because if you haven't removed subjects yet, for example, I don't know that you're going to remove subjects. I don't know if it's actually going to go firm. And so if those aren't provided to us, we don't know.
Excellent.
I don't know if you've gone somewhere else, you've called somebody else in the intervening months. So
exactly. And that, I gather, kind of brings us back to one of your original points, was really knowing as a buyer what steps you need to take to make sure that things are moving forward.
Exactly.
Okay, so our next question, this again is for you, Michael. So what happens if you go through all this, you have your conveyancing, everything's smooth, you take possession and you show up, and the home that you've bought is not in the same condition that it was when you first looked at it? And, in this example, the house has been trashed.
Call a handyman. Call 1-800-GOT-JUNK. Call somebody that can help you clean it up. Honestly, the reality is that, and it's what I touched on earlier about things not being in the condition that you expected. Even if you have contractual clauses for that, there are often clauses in contracts saying that the property will be professionally cleaned, and then you show up and there's a layer of dirt in the stove, and the shower looks like terrible things happened in it, or whatever. And people say, well, what can we do about it? I say, well, your contract does have a clause in there saying that the property is supposed to be in the same condition that it was viewed, or it might have a cleaning clause, or it might have that sort of thing in it. So you do have recourse against the seller if you do need to get into the, you do have recourse against the seller if you do have to pursue active litigation against them to recover your costs that you've suffered and taking it into the condition that it's supposed to be in, that sort of thing. But that also becomes a point of practicality. Is it really worth starting a lawsuit over $800 in cleaning and repair costs and junk removal or whatever? And maybe yes, it does. Maybe it's a point of principle, but points of principle are rarely good things to go to court over, because usually just costs more time and money than it's actually worth. And sometimes even just tracking the seller down can be a challenge, or trying to get anything out of them, it often isn't even worth it. So the practical answer is clean it up and carry on. Yeah. But the real answer is that yes, you could potentially have remedies.
Excellent. But it sounds like those remedies really aren't worth pursuing unless what you're dealing with is a significant problem, something more than
likely.
Yeah.
The only way to avoid that is what I addressed at the very beginning when I said, if you want to have a clause in your contract that says something like the buyer can do an inspection the day before completion, and if it's not in good condition, they can do a holdback for $2,000 or something like that. That's the only time. But a lot of sellers just won't accept that. In a market like right now, where it's a bit of a seller's market, a seller will just say, forget it. I'll sell it to the guy that doesn't care if I take all the windows when I leave. So
Exactly. Thank you so much, Michael. We are going now to move into the live Q&A portion. And so I'm going to stop sharing my screen so I can see everybody's questions. And as I do that, I'm going to ask Farnaz a question, which is, whose name should appear on title?
That's a very good question. It should be the individuals who are on the contract. A lot of time we get clients, oh, but I want to add my wife or I want to add my children. Well, they're not a party to the contract, so they should have been added to the contract. Or we receive mortgage instructions and there will be other individual names on the instructions that are not on the contract again. So whoever name is on the contract will have to be on the title. If you know that you want to add someone at a later stage, make sure the contract covers for that, because the seller doesn't have to, after it's been signed and everything said and done, the seller doesn't have to agree to another party being added. I mean, in most cases they do, unless they think you're making money off of it, but they don't have to. So I highly recommend who is going on the title. Check with your bank. Do they need another two people to be able to give you this mortgage? Do they need another two individuals' income on it? Then you want to make sure you add those people to the contract too.
Excellent. Thank you so much, Farinaz. So now we're going to start with our live questions. The first one is for you, Michael. Is there additional legal value in using a realtor as opposed to communicating with the seller directly?
Are there any realtors in the audience that often send me clients? Because I might answer it differently. No, realistically, yes, there is legal value. Adding the word legal in front of something is always a bit of a hard thing to do, because it's just value, period. And the reality is that a realtor will often help you with things that you don't think about. I used a realtor when I bought my house, and I had already been practicing real estate law for a couple of years at that point. So it's because at the end of the day, I'm not fully up to speed on all the market conditions. I don't really know what a property is worth. I don't necessarily know all the things to look out for in terms of condition of the property, or things that I learned about when we were exploring properties and that sort of thing, that I wouldn't necessarily have known about, or things in the area that might impact value and that sort of thing that a realtor can contribute to. So those are the more practical reasons. And then in terms of legal reasons, I mean, a realtor will often think of elements of your contract, like the realtor's job, despite how the contracts often say things like the realtor's not giving legal advice. That's actually exactly what they're doing. They are giving you legal advice. They're helping you write your contract. They're helping you come up with the clauses, and they will probably think of things that you might not think of when you're trying to deal with the seller directly, and therefore you're putting yourself in a position where you might not get something that you would have liked that the realtor could have helped you do, or you might lose your transaction because the realtor can help you negotiate it in a better way that you might not have been able to do. A realtor might say, you know what, putting that in is not going to be realistic. You're not going to get what you want. They won't accept your deal. So you have to decide if it's a sticking point or not. And so that's a lot of the value in a realtor: market conditions and just contract clauses and whatnot.
Excellent. Thank you so much. And I mean, that makes sense given that realtors are going through these types of transactions routinely. I mean, for most of us, we're not buying and selling homes frequently. Maybe some of us are, but it's usually very infrequently done by individuals, whereas realtors are doing this on a regular basis. So they know what to look for and how to help you. So thank you so much, Michael. I'll ask you, Farinaz, if you know the answer to this question. Are there resources for people who want to buy and sell privately without real estate agents? Our neighbor wants to buy our place.
Resources.
Yeah, resources for people who want to buy or sell privately.
You can prepare your own contract, but I mean, I would advise against that. Like Michael said, there is a reason there, you hire a realtor because they would know more of what to put in the contract as far as conditions, and they're there to look out for you. But I mean, I've seen private contracts between parties, and not sure where they always get those contracts. I know some notaries and lawyers prepare contracts. I do the odd time. I prefer not to, but maybe you'll find a notary or lawyer if you want to. I mean, but a notary or lawyer is going to charge you for that as well. So if you're trying to avoid the fees, the realty fees, then I would think just preparing it yourself. I don't think there is anywhere you can go and look up these contracts. Michael, do you know?
I'm not sure resource-wise what's available. I would usually say calling a lawyer or notary to help you with the process would be the only resource that I really know of in this situation. We do occasionally help people in private transactions. And yes, we do charge for it, but unfortunately we don't make the $30,000 that realtors do on a transaction. But you know, we just charge for time spent on helping prepare the contract. And so it can be anywhere from, I usually started at 500 and work my way up from there, depending on complexity and various, you know, condition removal items and that sort of thing that come up. But the reality is that it gets paid for one way or the other. You don't sell your house for as high of a price when it's a private sale, because the buyer wants to pay less for the house because you're not using the realtor. Versus, so if you're selling your house for $600,000 but you're selling it for $630,000 with a realtor, I mean, it kind of works out in the wash a lot of times, except for the buyer. And so the buyer has incentive to not go through a realtor in a case like that.
Excellent. Thank you both. That's very helpful. This next question, I'll ask you, Michael. How valuable is title insurance in resale?
Title insurance it doesn't add anything to the resale value of the home, but what it protects you as a homeowner against is a variety of factors that apply to ownership and not really condition of the property, but things that have led to condition of the property. So the standard things that it protects against are things like fraud and forgery. So if somebody were to commit a fraud and you know, fraudulently represent you and then take a second mortgage out on your property to run away with $200,000 or something like that, or if your home has no mortgage on it and they take a large mortgage out by misrepresenting, and it's a larger concern these days in the days of video meetings and that sort of thing. That's one of the big things that title insurance is for, fraud and forgery. And while not necessarily a concern, for the small cost of title insurance, to me, it's a bit of a no-brainer. But it also protects against things like survey related defects. So if it turns out that your deck is built into your neighbor's yard when you buy the property, and you know, you move in and the neighbor's like, well, we like the old people that lived here for 30 years, but we don't know you at all. Can you take your deck down, please? You're going to have situations like that, or, you know, lot line related issues with fencing and that sort of thing, versus municipal issues. You know, you show up, and I had this happen to a client of mine where they bought a home in Squamish and the district knocked on their house 2 days later and says, oh, we understand you have a couple of basement suites that were put in here without permits. And their property disclosure statement had said that permits had been issued for all the work done in the home. And so title insurance compensated them, helped them bring it up to code and whatnot. And it was about a $25,000 claim. So it's not really about resale. It's about your own ownership related thing. So.
Excellent. Thank you very much, Michael. This next question is, this is probably a question for you, Michael. If a realtor shows you the home and you're not too comfortable with that realtor, can you purchase through another realtor that you are more comfortable with?
Usually when you're working with a realtor, now a lot of this will depend on what your agreements are with that realtor. If you've signed any type of representation agreement or anything like that with them, not in the estate planning representation agreement, but for the realtor to act as your representative, any kind of agency agreement, then you might have obligations to that realtor. But that's not super common in buying real estate. But there might be other factors that are to do with MLS and realtor professional ethics, and whether or not the introducing realtor automatically gets some sort of cut of commission or that sort of thing. It gets into stuff that I don't really see on my end that much, so I'm not sure that I can answer it very well.
Yeah, fair enough. Fernaz, is that a question that comes up for you? I'm not sure.
As for the realtors, you mean? No, I mean, I must agree with Michael. It really depends on the agreement you sign with the realtor. Sometimes it's a contract where you sign and you say, you know, for 6 months, I'm going to show you homes. You know, it's a binding contract. I don't know. I don't know if you could then go to another realtor, and that realtor might have to share the commission with this realtor if they find a house and you still have this agreement in place. I can't say.
If you
Yeah.
did have an agreement like that, you'd have to get a release if you wanted to,
Yeah.
not have any obligations. I don't think buyer agency agreements are very common. I don't think.
I've seen a couple.
Yeah.
I have seen a couple buyers agency agreements where the client came to me and wanted me to review it and make sure, if they wanted to get out of it. And I was like, oh, it's not something I normally do. But yeah, like Michael said, it's not very common. I think it's more listing because, yeah, it's just not as common, but I've seen it.
Okay, thank you. Thank you, both of you. Here's this next question. If we buy a home together with our children, they put in some money and we put in some, and we are going to live there, I'm guessing this would be a good time to get a lawyer to set up the agreement between us. And so I gather this is probably a question for you, Michael. What are your thoughts on that?
Generally, yes. A co-ownership agreement is a pretty important thing to have in place. We often have people saying, oh, we all trust each other. It's fine. We don't need anything. We don't want to spend the money on what it would cost to get something put together. Because, at the end of the day, our hourly rates for that sort of thing are where things can add up. And the problem is that everything's fine until it's not fine. And I know that sounds a bit trite, but at the end of the day, that's the reality, is that nobody needs an agreement until they actually need to be relying on something to enforce their position in an agreement. And so the idea behind co-ownership agreements is that it helps to define people's obligations, rights, termination, if somebody wants to get out of it. Because, for example, two people going to buy a property together and one says, what, we can't afford this anymore. We need to get out of this. So we need to sell the house. And the other party says, but I can't afford it on my own. Well, it's not really fair for that party to hold this party hostage and something that they can't afford. And so the co-ownership agreement will have termination rights. So usually a right of first refusal for party A to buy out party B, that sort of thing. And then if they can't do it, then the house would get listed for sale under certain clauses and that kind of thing. So.
Excellent. And how would that work timing wise, Michael? So you have your co-ownership agreement that you're preparing. You have ultimately your purchasing of the home. Where does the timing fit in? Is that an agreement then that you would be executing when you're doing your completion, or how does that work?
Ideally, it would happen before completion, like the agreement would be entered into before completion. It's not necessary to have it done that way, but if one party doesn't want to sign it after completion, then you're sort of stuck in a position without having it. And it will usually involve independent legal advice as well, because it would be incumbent on me as somebody who's prepared the agreement to make sure that everybody understands it, and that I can't really properly act for everybody if they have competing interests, for example. So it would usually require independent legal advice, because usually that agreement's at the impetus of one of the parties instead of all the parties, or that sort of thing. So, but it can come up after the fact. I've had people just write to me afterwards and say, we own this property together. Can you prepare a co-ownership for us? That kind of thing.
Fabulous. Thank you so much. I'm going to ask one last question. I know that we're pretty much at time. We've got a couple minutes left, and I'm not sure if this is a quick answer or not, but can a refugee buy a house in Canada? This person who wrote in does not yet have government refugee status.
I can take that if you want. Anybody can buy property, but they would be considered a foreign buyer for the additional property transfer tax, or commonly known as the foreign buyer tax. And so they would have to pay the 20% additional property transfer tax, even if they're applying for refugee status. And a refugee is not a permanent resident and does not qualify for exemption from the additional property transfer tax. So even if you have refugee status, if you don't actually have permanent residence, you would still have to pay the ATT as well.
Super. Thank you so much, Michael. And I just want to acknowledge there's a number of questions in the Q&A. Thank you, everybody, for putting your questions in. I'm sorry that we're not able to get to all of them, but thank you for putting those in. And thank you both to Farnaz and to Michael. We are going to wrap up. Before we do that, Farnaz, is there anything else that you'd like to add before we wrap up today's webinar?
No, just the last question. If you have applied for PR, I believe you can still be exempt from the tax. Is that right, Michael?
There are certain circumstances where that's the case, particularly for BC provincial nominees.
Right.
But I don't think it applies to refugees. I'd have to double check.
Right.
And somebody who doesn't even have refugee status yet, definitely that wouldn't apply to. But the other thing is that if you become a PR within 12 months of completion of your purchase, you could potentially get the additional property transfer tax refunded. I think it's 12 months. I'd have to double check that though. That's, just off the top of my head. So.
Super, and it's very helpful to have that issue flagged as well as something to look into further. Thank you so much. Michael, do you have anything else that you'd like to add before we wrap up today?
No, not really. Just really don't go in blind and don't think that it's everybody else's responsibility to take care of you along the way. Because you don't want to have a situation where you turn around later and say, I didn't know, or that's not what I thought. If you have something that you need to flag, you need to let us know, because we don't know everything about your opinions or your views on stuff. So if you let us know, then we can help with it.
Fabulous. Thank you so much. Thank you so much. Thank you again, Farnaz. Thank you, Michael. It has been such a pleasure having you here today. And I know the information that you shared with us today is so helpful to everybody who has signed into today's webinar.